Does committee want to have discussion before we turn to two sets of findings of fact?
Yeah.
All right, Mr. Scholl.
A couple things I want to mention. It concerns me that in the state's documents, they have 48 different items that they talk about that is transferred to the findings of fact. 23 of them, 1 through 24, kind of apply during Mr. Ridenour's time, his involvement in what went on. Numbers 25 through 47 are after March, when he wasn't even involved. And number 48 is the time that he was at the school, that I think the video showed doesn't corroborate what the student or what it actually says in there. And so that concerns me. And I was an assistant principal for 6 years. That was about a little less than a quarter of my career, about 20% of my career. And I can see myself doing exactly what happened. And it's concerning, and I'm glad that Mr. Power is no longer in the profession, hindsight being 2020. But that initial contact with them, and the letter of direction and the contacting of the students and offering the students what they did, I could see that happening. And I think that could be considered reasonable. Now I'll leave it at that.
Other discussion?
If I could.
Yes, Mr. Embo.
When you make the choice to cross that aisle from teacher to administrator, the responsibilities grow demonstrably, and you know that going in. You're tasked with creating and maintaining a safe learning environment. You're to advocate for students while balancing the due process of teachers. A couple of things that I pondered throughout this. Was this investigation conducted for expedience or thoroughness? Why were the students that were interviewed originally, there were other students that were referenced, why weren't they additionally interviewed for more information? The term chain of command came up on several occasions. Mr. Ridenour used it back on day one of this hearing. It was also alluded to by Ms. Woodworth, as well as defense counsel today. And my question on that is, when you talk about chain of command, does turning over a matter to a superior absolve you from additional scrutiny? And I'm always fearful when is chain of command it should not be deployed as a matter of convenience, but as a methodology for problem solving to get to the best possible decision via discussion.
Thank you. Ms. Talton, I believe you were going for the microphone.
Yes. In reference first to document 1 that member Scholl brought up, well, if I were to make a motion on whether or not to use document 1 or document 2 for our findings of fact, I would choose document 1. I agree with paragraph 48. I don't think 48 is necessary for what we're called to do today. And I understand your reasoning or your ideas about the other paragraphs. However, the reason I think they need to be included is because what they do point to is the harm that resulted because of the limited action that was taken. And so I think that they're necessary. 48 would be the only one that I would be okay with omitting. And ultimately, since we're having the discussion, children were harmed in this situation. I think this is my 8th year in this position. And so I've heard a lot of cases. This is my 22nd year in education. I have assumed many roles on campus, from leadership, teacher, mental health provider. And as I have gone through this case multiple times, all of these pages, I keep coming back to the same thing. Children were harmed. That is evident. That is clear. Everybody can agree. Children were harmed, and not enough was done to correct that harm. And I think the inaction is what caused the residual harm. And I can't be a part of continuing that idea. And so I disagree that reasonable efforts were made to protect the student. And because of that, there is a discredit to our teaching profession. I think public trust was broken. And just as an individual sitting on this committee, I can't participate in the continuing of the harm. And and so I think all in those first 47 are important, because omitting the what happened after is a participation of further harm of students. So I'll leave it at that for now.
Dr. Klinick?
You said that very well. So numbers 1 through 47 were the ones that I was looking at as well. 48, it's important, but I don't think it's necessarily applicable to this case. For something that you mentioned being an assistant principal for 6 years. I was as well. And if it were a rookie mistake, as you might say, that would still be a problem, but he wasn't new to the profession. He was not new to the role. He'd been in that position and has substantial experience, and I don't think it's, I think it's something he should have been able to address more thoroughly. Also, I want to talk about the letter of direction, because that's kind of bothering me. So a letter of direction, I've been in 3 school districts. It's always been administrative, not disciplinary. As an administrator in 3 districts, I've never experienced where that actually goes in the file. So it's noted, HR might review it, but it does not typically go in the file. That's a letter of reprimand. So at least in all of my experience in 3 districts. Also, in the letter of direction, it does state that it could be considered grounds of dismissal. So I'm not sure why that's being overlooked as well. So if it's severe enough where that's even put in the letter of direction that it could be grounds for dismissal, why is it only a letter of direction? And then I also agree that there is that mental harm that was happening towards students, to the point where it was testified earlier that one student actually had recommended counseling. So if we need counseling, we need classrooms changed. How is that not harm towards students? That's recognized in February. Thank you.
Thank you. Further discussion?
Yes, I do.
Yes, Ms. Alonso.
I was going to focus on that mental health piece in particular for these children, because we are talking about children, and what message we're sending these girls. As we know, there were no male students that came forward. They were all female students. And statistically, we're looking at roughly 1 in 3 women nationally who are harmed in some way or another, or touched inappropriately, or victims of unwanted touch. We're also looking at a roughly 80% of women who don't report, simply on the basis that they're not believed. And I feel as though I cannot be a part of furthering harm in the way my colleague, Member Alonso said, or Member Hilton said, that contributes to girls not reporting things that have happened to them out of a fear that they're not going to be believed once they're reported. And then there is also a high re-victimization statistic that goes along with anybody who is a victim. That they will never report it because the adults failed. And I can't be a part of a decision where that is overlooked or not considered because they do not get the privilege to say this was 5 years ago and I don't remember. You're asking me to recollect something 5 years ago and I can't remember. They're going to remember every time that they did not want to be touched and were. And they don't have the privilege to forget what the adults' faces looked like, who did not follow through the way that things should have been followed through on.
Thank you. Further discussion? Right. You have been presented with 2 sets of proposed findings of fact, conclusions of law, and recommendation. Vice Chair Helton referenced document 1, and as did Member Scholl. But you also have document 2 to consider in front of you. So if there's no further discussion, I will entertain a motion from either document.
I move that we use document 1, the state's proctored proposed findings of fact and conclusions of law for the rest of our proceedings.
A second.
Okay, it's been moved and seconded that you use document 1 for the rest of your proceedings. Is there discussion? All in favor?
Aye.
Aye.
Opposed?
Aye.
I'm sorry.
Opposed.
Thank you, Member Scholl. I did not mean to exclude you.
Right.
The motion carries. So the committee is using document 1. Is there a motion concerning the findings of fact?
I will.
Helton.
I will move to include, let me go back up, the findings of fact, numbers 1 through 47, and omit number 48, paragraph 48.
Is there a second?
I second.
It's been moved and seconded that the committee use findings of fact 1 through 47 on document 1, omitting number 48. Is there discussion? All in favor?
Aye.
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 Opposed?
Aye.
The motion carries. In document 1, the state has presented aggravating and mitigating factors for you to consider adding to the findings of fact. Are there any aggravating factors the committee would like to add to the findings of fact? Dr. Clinic.
I move to add aggravating factors, F, vulnerability of the victims, and G, substantial experience in the field.
Is there a second?
Second.
Thank you. It's been moved and seconded that the committee add aggravating factors F, vulnerability of the victims, and G, substantial experience in the field. Is there discussion? Hearing none. All in favor?
Aye.
Aye.
Opposed? The motion carries. Are there mitigating factors you would like to add to the findings of fact? Hearing none. In document 1 are conclusions of law for you to consider. Is there a motion concerning the conclusions of law?
I move that the PPAC accept the conclusions of law 51 through 57 as presented.
Is there a second?
Second.
Thank you. It's been moved and seconded that the PPAC approve conclusions of law 51 through 57 as presented. Is there discussion? Hearing none, all in favor?
Aye.
Aye.
Opposed?
Aye.
The motion carries. The final issue for discussion for the committee is the committee's recommended order to the Board of Education. The committee may consider any of the following actions alone or in combination pursuant to ARS Section 15-203A. Take no disciplinary action against the respondent. 2, issue a letter of censure to the respondent. 3, suspend all certificates for any length of time up to 5 years. 4, suspend the certificate and impose conditions. 5, revoke any and all certificates held by respondents and that all states and territories be notified. Is there a motion concerning the order to the Board of Education? Ms. Halton.
Based on the foregoing findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through a 3-year suspension to start after the end of the respondent's current suspension, and that any and all certificates, and that all states and territories be so notified.
Is there a second?
I second.
It's been moved and seconded that based on the foregoing findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through a 3-year suspension to start after the end of respondent's current suspension. Is that correct?
Mhm.
And of any and all certificates held by respondent, and that all states and territories be so notified. Do you want me to try that again?
I think you got it.
Okay. Did I get a second? Thank you. Thank you. Is there discussion? Hearing none, Ms. Stolro, please call the roll.
Vice Chair Helton,
Excuse me, I vote aye, with explanation can be taken from my discussion at the beginning of our deliberation.
Member Alonso,
Aye.
Member Ambos,
Aye.
Member Dr. Clinic,
Aye.
and Member Scholl.
Nay. And with the same caveat, my vote is based on the conversation that we had at the beginning of this, at the discussion.
Hearing Officer Lee, you have 4 ayes and 1 nay.
Thank you. By your vote of 4-1, based on the foregoing findings of fact and conclusions of law, the PPAC recommends that the board take disciplinary action through a 3-year suspension to start after the end of respondent's current suspension of any and all certificates held by respondent, and that all states and territories be so notified. This concludes the formal hearing. The committee's decision will be reduced to a written recommendation and delivered to the Board of Education. The board will make the final decision. Each party will receive notice of the board meeting at which it will consider the committee's recommendations. The parties will have further appeal rights that will be explained in the final order issued by the Board of Education. Thank you for your attendance today.